So many of you have been texting me and emailing me and really inquiring about COVID, about coronavirus. What is the school district's responsibility during coronavirus? So today, I'm going to answer your questions. I'm going to get to it and try to address all those concerns. Ladies and gentlemen, boys and girls, YouTube, thank you so much for coming back. My name is Eli, I am the lawyer guy, and today we are going to be going over some current events. You may or may not have noticed that things are a little bit weird these days. COVID, coronavirus, it's out there, and it is really messing up educational services for everybody. Today, we are going to be looking at what is the school district's actual responsibility to your kiddos during the coronavirus. What is it that they have to do? What is it that the law says is appropriate? And maybe clearing up some of those misconceptions or questions that are out there to address your specific circumstances. So what I'm going to do is I'm going to go over a little bit of history. I'm located in California. My legal practice is located in California, so I'm going to be talking a little bit about California, and then I'm going to get a little more general in terms of federal responsibilities and what the federal law says that school districts have to do for your kids. So bear with me a little bit. If you're not from California but watching my videos, it will come back around to you as well, and information will be very pertinent to anybody that's from any state. So coronavirus, COVID-19, I'll be using both of them interchangeably during this video. As we know, there's been hundreds of thousands of millions of cases, hundreds of thousands of deaths in the US from the coronavirus. It has a specific set of symptoms. Some mirror the flu, some do not. I want to let you guys know that this is not a political video. I will not be addressing political issues, and if you want to go ahead and go check out a political video, please go elsewhere. Today we're just going to be talking about educational responsibilities, okay? So in terms of the way this has progressed, so we're looking at about March. President Trump declared a national emergency based on COVID here in California. Right around that same time, school districts started to close schools, right around the last 2 weeks of March. Also during that time, our Governor Newsom, put out an executive order which stated that school districts would continue to be funded so that teachers could get paid and educational services would be able to continue. And that was done right on March 13th, 2020. All of the documents that I am talking about today, I will link in the description so that you guys can go ahead and just click on them if you want them for reference. Again, some of them have to do with California, some of them are federal, so if you want those for reference, those will be available by links down in the description. So after that, Governor Newsom, our governor in California, signed SB 117. Now, this was an emergency measure, and according to a lot of us, it was overreaching and unnecessary, but it provided for a relaxation of certain standards here in California for school districts. The biggest one that affected parents and students here was the burden to provide school records was completely relaxed. And in California, you have to do so within 5 days of receiving a request. And that standard was relaxed such that parents were struggling to get their school records in a timely manner or even at all. And that continues actually today, which continues to be a struggle for parents to be able to access their right to due process for their kids.
Boo!
So a few days after that, March 20th, 2020, our state Department of Education, the California Department of Education, or CDE, released some standards. Now, one of the first things that those CDE standards stated was that federal law still remained in place. So as of the end of March, while states were scrambling and trying to do what they could do, federal law, the IDEA, and Section 504 of the Rehabilitation Act remained in place in full. So school district responsibilities were exactly the same as they had been before. What the CDE report stated was districts could approach the COVID responsibilities in a certain manner, whether that be distance learning or contracting with non-public agencies to provide educational services. Under certain limited circumstances, they could consider educating small groups. different things, but it also stated that eventually what needed to be considered was parents' access to compensatory services if they had lost out on certain services during the period of school closures and even afterwards. Now that's very relevant, and that's going to come back around to work towards everybody's favor, because if you have lost out on services, there are certain things that you can expect for the school district to have to do for you, and we will address those a little bit later in this video. That CDE report, it said, like I said, nothing's relaxed, everything's still in place. However, if you file a complaint, they will take into account school closures for purposes of addressing your complaint. For instance, if you say, well, my child lost out on a free and appropriate public education because they didn't receive anything for 10 days, they're going to say, look, during those 10 days, the school district was scrambling. We all were scrambling to try to figure something out. So we're not going to hold their feet to the fire just for that small amount of time. Things of that nature during that time for that analysis.
Boo!
On March 27th, 2020, Congress passed the CARES Act. Now, a lot of you know the CARES Act. It's been in the news. It was in the news for, purposes of talking about economic stimulus, loans for small businesses, things of that nature. But however, the CARES Act is relevant to education because Congress stated that within a certain amount of time, the U.S. Department of Education had to release a report. Specifically, the Secretary Betsy DeVos, had to release a report which talked about special education services and any waivers that would be had as a result of the coronavirus and, to be necessary in the view of the federal government. And I'll be honest with you guys, as an education attorney, I know I was, and I know a lot of my colleagues were very nervous about this because that provided Secretary DeVos with the ability to completely suspend the IDEA if she wanted to, unraveling years and years of hard work to try to support our special education kiddos and 504 as well. These programs that are intended to assist kids with disabilities. So we were kind of on pins and needles waiting for that report to come out. On April 27th, 2020, that report did come out, and we all breathed a collective sigh of relief. Secretary DeVos did not relax any substantive part of the IDEA absent one, which actually makes perfect sense given the circumstances. The only thing that was relaxed was the time for kids who are turning 3 to transition into the school district. At that period, kids need to be assessed by the school district in order to ensure appropriate transition services. But if there is no in-person services, there is no in-person testing, so they can't do testing. So what they wanted to avoid was children transitioning and not being put into appropriate programs. So they said, look, they can continue at their prior program even after age 3 until such time that they can be assessed and appropriately transitioned. That was the only substantive change that was made. Now, not only did Secretary DeVos not relax these IDEA provisions, she actually reaffirmed school districts' responsibilities in regard to providing special education services. I'm going to read a little bit about what she said in the preamble to this report. Provided that schools can and must provide education to all students, including children with disabilities. The health and safety of children, students, educators, and service providers must be the first consideration. The needs and best interests of the individual student, not any system, should guide decisions and expenditures. Parents or recipients of services must be informed of and involved in decisions relating to the provision of services. And services typically provided in person may now need to be provided through alternative methods, requiring creative and innovative approaches. All very reasonable, all very good restatements of a school district's and parents' continuing responsibility despite the COVID problems. That was April 27th, when the opportunity for federal law to be relaxed came and went, and it was soundly defeated. So the federal responsibilities under the IDEA, if you have an IEP, or Section 504, if you have a 504 plan, remain in place. I'm going to say that again. They remain in place. They were not changed. They were not relaxed. Nothing. Everything that the school district had to do for your child prior to March 2020, they had to do after March of 2020. That remains in place. That is a very common misconception, and it's being communicated by people in authority. And it's not true. It's just not true. Your children are entitled to a free and appropriate public education under the IDEA or 504 now. as they were before. That has not changed. What have we been seeing? What has my personal experience been with these COVID procedures? Number one is that some school districts just aren't delivering services. They are saying, look, we don't have the personnel to be able to deliver the services. We don't have the funding to be delivering the services. This has been reported to me in numerous cases for numerous services. Other people are reporting that school districts are delivering some services, but not others. Other people are reporting that they're delivering services in a kind of one-size-fits-all distance learning, saying to parents, look, this is what we're giving to everybody, so this is what your child will get as well. And in all of these cases, this breaks the law. Your child is entitled to a free and appropriate public education, an individualized plan. And that needs to be provided. That needs to be implemented. If it needs to be changed somehow, then they need to have an IEP meeting, sit down with you and say, look, we want to be able to appropriately serve Johnny, but we need to change some things now based on the distance learning. And you have that discussion and you come to an agreement about what would be appropriate, maybe a little bit different. But simply stating we're not going to do it, or we're only going to do certain things but not others, that breaks the law. The same as if you were in in-person learning programs. We do. Number one, you contact the school district immediately if your services aren't being delivered. And you say, look, I have an IEP document that states that these are my services. You need to arrange for these services to be delivered immediately. If you can't do it, then you need to contract out with a non-public agency and have them do it. Because every day that you don't deliver my IEP services, my child loses out on a free and appropriate public education. And that's it. That's cut and dry. So once you notify the district, they should be scrambling either to get your services in place or to set up an IEP meeting or a 504 meeting to talk about, okay, how is this falling through the cracks? How can we fix it? And what can we do to make sure that this is appropriate going forward for your child? If your child needs to be assessed, then request assessment. In-person assessment in a lot of places is not taking place right now. That does not mean that you don't want to get that on the books for when this starts taking place. Because once in-person services start, the school district is going to be inundated with assessments, and you want to be first on that list. You want to be the person that says, look, I got my assessment plan signed way back when, and so my assessment needs to start immediately, because they're going to be subject to that 60-day timeline, and if you don't request it now, then you're going to be at the back of the line when school districts start again. If your child is receiving in-person services, then everything is in place. School district requirements to hold IEP meetings and do assessments, all of that is in place. So just because it's COVID does not change their responsibilities under the law. Guys, I talked about what are called compensatory services earlier. Compensatory services are services that are owed to a child because the school district has not given them appropriate services in the past. So if they've lost out on educational opportunity, the school district owes them that educational opportunity. And those come in the form of compensatory services, whether it be tutoring for academics, speech and language services, OT services, PT services. Any service can be delivered in a compensatory method. Now, the California Department of Education here in California directly stated that there is going to be a significant amount of compensatory services that are owed because school districts have been unable to comply with kids' IEPs. And if you are in that boat, then you need to go after the school district to do that. If the school district ignores you, then you need to go to your state Department of Education or consult with an attorney and see, look, am I owed compensatory services? Is that something you can help me with? Because you need to hold their feet to the fire. The district has denied you access to educational opportunity, and so they owe you that educational opportunity. That's their responsibility. Here in California, the agency that hears our matters is called the California Office of Administrative Hearings. And there have been multiple cases now that have come down, official legal matters that have been litigated and come down as case law that have stated directly that if the school district is not providing services that are substantially similar to your IEP for a lengthy period of time, they are breaking the law. Now, this has been children who are in a special day class and the school district has put them on distance learning and boiled down their 5-hour, 6-hour a day special day class to an hour distance learning Zoom call. That has been found not to comport. Other matters have been found not to comport, such that this person is owed compensatory services. So there are legal matters that are going right now that have found formally that these school districts are responsible. This is not me being a crazy activist, being a student side education attorney and trying to drum up business. This is happening. That parents are saying, look, my child has been losing out on weeks, months appropriate services. I'm killing myself at home trying to make this work, but you're not doing your part. Again, guys, if you live in California, if you don't live in California, if you want to take one thing out of this video, take this. The school district is responsible to give your child a free and appropriate public education, whether you're qualified to receive an IEP or you're qualified to receive accommodations and modifications under Section 504. That is the school district's responsibility. If they are not doing it, then they are breaking the law. These responsibilities have not in any way been relaxed or gotten rid of by federal law. Federal law has never changed. It has been in place this entire time. So if you feel like the school district has dropped the ball and owes your child educational services, you need to go to the school district and say, look, I need compensatory services because my child's lost out. And if they ignore you, go to your Department of Education. Go talk to an attorney. Make sure that your child is compensated with these services that they've lost out on. And if it's a continuing violation, if it's something that's happening right now and it just keeps happening, then hold them accountable. Call IEP meetings, request assessments. All of these things are still in play. Nothing has been changed. Now, you might have to talk to the school district about what's available and what they can do for you, and maybe it's not going to be identical, but it has to be substantially similar. So make sure that it's substantially similar. Be your child's best advocate, guys. Do the work, all right? Nobody else is going to do it for you, and school districts right now are just scrambling. And so you're going to need to be that voice for your child, all right? So that's some COVID stuff, guys, like I said, I've been getting calls, texts, emails about, and I wanted to just drop a quick video about it. If you have questions, if you have specific questions, feel free to drop them down in the comments. Let me know, how's your IEP going? What has been your experience, especially out of state? I'd love to hear from you guys that aren't necessarily in California. How's your experience going? If you're doing in-person learning, how's that going? Again, I hope you guys are all staying safe, healthy out there, and that your kids are doing well. That's my hope. That's why I do this. So until next time, guys, have a great day, and I'll see you next video.